Okay, so let's make sure, Alma, are you back? Are you in the Spanish room? Yes. Okay, so Alma's in the Spanish room, so if you want to begin, and thank you for your patience.
Well, good afternoon, good evening. As Nellie said, I'm Rose, and Amanda and I are going to kind of go back and forth between this presentation and take turns with our presentation. And so the first thing that we, if we could go back one.
Sorry about that.
That's okay. Is that this was a two-part series. And so if you weren't able to join us for the first session, we hope that you will watch it. We have recorded it and we will be making it available on our website in about a week. And so if you would look on our website in a week, you can have a link to a YouTube video, which will you can learn more from session one. In session one, we covered what anti-discrimination laws protect students with disabilities and on the basis of disability and other protected groups. We talked about what are extracurricular activities, what's the scope of those. And we learned that that is a large scope. It includes things like athletics, intramural sports, clubs, dances, student government, field trips, academic competitions like mathletes, career and employment opportunities to teach students about career choices or get work experience. All of those kinds of things would be under curricular activities. Your schools may have fewer or more of those, but it's a broad range of activities. And we also heard from a young woman who was a former high school athlete who talked about some of her experiences where she felt discriminated against during her high school career, and steps that she took to try to resolve that matter and how that worked out for her. And we also covered things about what schools are covered, which includes public schools and charter schools and universities, unless they're and with the limited exception of private religious schools. And we talked about who's protected and types and examples of discrimination. So if you have a chance, you can check out session one. Tonight, though, we're going to really focus on reporting discrimination and harassment, because sometimes schools will know about harassment because it might be a high-level official engaging in the discrimination or harassment. But when it's other students, when it's maybe visitors to campus or other employees who don't hold a high position, then the school isn't going to know about it unless you report it. So we're going to talk about reporting harassment and discrimination, types of relief that you might want to request in order to address the problem, correct the problem, and remedy the effects of the problem had. Using internal grievance procedures when notification didn't work, and then how to file with outside agencies as another alternative to resolving discrimination and harassment at schools. We'll also be talking about tips for filing good complaints and what to expect when you filed a complaint. So one of the things that we covered in both sessions tonight and last night was what laws are involved in this, what protections what protections exist. So one, for kids with disabilities, students with disabilities, it's Section 504 of the Rehabilitation Act and Title II of the Americans with Disabilities Act. And so both of those prohibit discrimination and harassment. Now, many of you may have students who have IEPs and are protected by the Individuals with Disabilities Education Act. And it does have some implications. Oftentimes accommodations have to be put in for other types of like extracurricular activities or field trips, but we're going to focus on the discrimination and harassment laws. If your child has a 504 plan, then you're familiar with Section 504 of the Rehabilitation Act and its anti-discrimination provisions. Title II shares very similar requirements, responsibilities to schools, and protections for students. But these laws protect students with disabilities, but sometimes students are discriminated against because of another membership in another protected group. And Title VI of the Civil Rights Act prohibits discrimination based on race, color, or national origin. And Title IX of the Education Amendments Act prohibits discrimination based on sex, and that includes LGBT status. So, so students can be discriminated against on one ground, and sometimes they're discriminated against on the basis of kind of an intersection of two protected groups. Like maybe a student who is in the LGBT group and has autism might be subject to a harassment that other students who just have autism or other students who are in that protected group are not facing. Or you may have someone, it's a student may be subjected to discrimination in certain events because of her gender and her intellectual disability. So it can be and we will see that these laws and these grievance procedures can allow people to bring up more than one type of discrimination. So I'm going to turn it over now to Amanda, who's going to talk about tips for notifying the school when discrimination or harassment occurs.
Great, thank you, Rose. So when you're in one of these situations, as was discussed last night, you're a member of a protected class and you're facing discrimination or harassment at school, the first thing that we would recommend that you do is put the school on notice, meaning tell the school what's happening, make them aware of the situation so that the school can take appropriate steps to try to remedy what's going on. So we can't just go out and sue the school right away because the school is only going to be found liable for what's happened, meaning they're only going to be held responsible for what has happened if you've provided them with enough notice and given them an opportunity to remedy the situation. So the first thing we got to do is make sure that the school is aware of what's happening so that they have a chance to take action. And then if they fail to take action, that's when you've set up a nice case to go ahead and file a complaint against the school for their failure to appropriately address what's happening to you. So when you're providing notice, we definitely recommend you do it in writing. Sometimes it's okay to provide notice verbally or make an oral complaint. But as lawyers, we're always going to advise you to put your complaint or your notice in writing because it's good to have documentary evidence of what you have told the school. That way later, the school can't say, you never told us, because you have a copy of the letter or a copy of the email that has the exact date and time when you sent it, and it shows exactly who received that letter. So you definitely want to put it in writing. You do want to address it to a specific person because if you just send it to, XYZ school, you're not sure who's getting it. It might be somebody like a secretary at the front desk. We want to make sure that the letter is going to a person who is able to actually read it and take the actions that you're looking for. Sorry, my light went out, but I think you can still see me. I'm lit up by my computer screen. So you are going to want to choose someone with some authority. So our suggestion, I think the best person to write your letter to would be either an ADA, Americans with Disabilities Act coordinator, or a Section 504 coordinator. And you can typically determine who that person is by looking at the school's website, or you could always call the school's main number and ask for that contact person's name and email or mailing address so you can send them the letter. Another really good person to address your letter to would be the special education director. So even if your child doesn't have an IEP or you've never contacted the special education director before, the intersection of special education and disability related civil rights issues is pretty close. And so even if they're not exactly the right person, they will be aware of who they should forward it on to. And often we do see that the special ed director also serves in a dual role of also being the ADA or 504 coordinator. So it might be the same person in any case. And then you can kind of go even above their heads and address it to the superintendent. So typically districts will have a superintendent. Charter schools, they may have a superintendent or they might be called the executive director or the CEO, but we're kind of looking for the number one person right at the top of the organization. And even better than just sending it to one of these people would be to address this letter to all of these people. You can copy everybody so that everyone's aware, and hopefully your letter makes it into the right hands that way. You're casting a wide net. So what do you put in the letter? In the letter, you want to make sure that you point out that this school, whether it's a charter or a district, if we're talking about a community college or a university, point out that whatever the school is, it's a recipient of federal financial assistance, because that's important for coverage under Section 504. Section 504 only applies to schools that are receiving money from the federal government. So you definitely want to make that statement up front so that the school knows they're covered by this law. And then you want to provide what's happening, information about what's happening. So this is where you really want to put in a lot of detail, I think, about exactly who's involved, exactly what the actions look like, when did these actions happen. You could include a timeline of events. It's also great to include evidence that you may have, if you have photographs of property damage, or a copy of a text that your child received from a bully in school. Anything that you have that supports your description of the harassment is really helpful to include. Then you want to state, this is not something happening off campus or outside of school. This has a direct connection to school. And sometimes that can be tricky, because if we're talking about an extracurricular activity, a school might say, well, that was after school hours, it's not our problem. But you need to kind of demonstrate, even though it's extracurricular, the school still has control over this situation. So yeah, maybe it happened during cheerleading practice, which is after school, but the cheerleading coach is a school employee. The cheerleaders are using the school gymnasium. Everyone involved is a student at the school. So you want to show that the school has control over this situation, even if it's extracurricular. It's not happening in math class, but it's still on school property, still overseen by the school, and the school still has control to remedy the situation. So really draw that connection in your letter so that the school realizes this is their responsibility. Next, we want to make sure that if we're talking about incidents, we are explaining that they are severe and pervasive. So putting a school on notice of one minor incident that happened 5 years ago and never reoccurred is probably not going to be sufficient for a complaint. If your kid got called a name once and it was a long time ago, but you just joined us here today, and so you learned about this option, so now you're going to provide them with notice and a letter, that's probably not going to be something that you're going to file a successful complaint over. So what you're going to want to put in your letter is an explanation and details about why this is not just, a one-off thing or a casual comment that was made. This is severe. It's having an intense emotional impact on you or your child. It's impacting their grades. It's impacting their ability to attend school. They're feeling excluded. It's severe and pervasive. So it's not necessarily just a one-time thing, although a one-time incident could, if it's severe enough, could definitely be something you'd file a complaint about. But pervasive is also helpful. So it's not just, one random person, it's happening. Everybody on the team is making fun of this kiddo, or the coach is encouraging an environment of hostility toward a kiddo, or it's happening regularly, not just once. So as much as you can, emphasize both the severity and the pervasive nature of the harassment.
Amanda, could I add one thing?
Absolutely.
So really, we should have said severe or pervasive. So you could have it, you don't have to have both. So it could, you could have just or. So it could be severe. It could even be a single incident if it's severe enough. But if you're going for pervasive, showing it's pervasive, then you have to show a lot of incidents. So just wanted to add that.
Thank you. And then we want to make sure we're showing that this is not just something that happened, but the impact of what happened. So it resulted in your child being excluded in participating in this activity, or it's resulting in your child being denied benefits that other students have. So for example, let's think about a field trip, which could be an extracurricular activity. So if your child has a disability and the school district is going to be busing kids to the zoo, but they don't have an accessible bus and your child uses a wheelchair. As a result, the school says, well, either your parents can take the day off of work and pick you up in their personal accessible vehicle and drive you from school to the zoo and back, or you're going to miss out on the field trip. That's a pretty clear example of how you're being excluded on the basis of your disability, whereas all the other students are benefiting from and have access to that extracurricular activity. Sometimes it's not quite that clear. Sometimes it could be that, you know, you're being bullied in an after-school activity. Nobody said you're not allowed to come to that after-school activity, but the bullying that you experience every time you go is so severe and causing you so much trauma that you no longer choose to go. And so while other students are able to participate in drama club or marching band or whatever the activity is, you're being denied that because it's such a hostile environment that you don't choose to go or your child doesn't choose to go. And then finally, and perhaps most importantly, you need to explain what you want the school to do. So just complaining about what's happening is good, but it's really important that you tell the school what steps you want to see them take in order to adequately and appropriately address the harassment and resolve the issue. So if it's a single student who's bullying your kiddo, does this mean maybe the school needs to look at moving that child to a different classroom? If it's an issue with the staff member, does the staff member need to undergo training, sensitivity training, or perhaps be placed in a different position? You know, if it's a field trip issue, does the school need to purchase accessible vehicles? So I think there's a lot of different ideas you can throw out, and it doesn't have to be just one. You could list out any possible solution you would be happy with, and you could say any or all of these would be great. And so definitely include that in the letter as well. And then you are also going to want to ask for a copy of the school's policies for filing these complaints. So those policies you can ask for directly. Sometimes you can even find them online on the school's website or on a policy website just to see what the steps are. Because sometimes the policy will tell you who exactly you should be submitting this to. There might be timelines for when you could expect to get a response or a resolution to your complaint. So it's good to know what the policy is so you can make sure the school is actually following its own policy. And then you kind of want to end with a demand. So we would call this a demand letter from a legal perspective. So essentially, if you do not take the steps we're asking you to take or otherwise investigate and remedy this situation, we, you may be liable. We may be able to hold you liable in a different way unless you take these steps. And it does show that the school is demonstrating deliberate indifference to the discrimination. And again, that's why it's important to put them on notice, because if they're not on notice, we can't say they were being indifferent because they didn't know about it. So we got to make sure they know about it. They have a chance to fix it. And then if they fail to do that, then we can claim they were deliberately indifferent to this discrimination that was happening on their watch. And then a bonus tip, you can actually put in a date yourself for when you expect to hear back from them. So, you know, let's say I'm sending it today, November 4th. I expect to hear a result a week from tomorrow. So by next Friday, and you would put the date in, or, you know, typically it's going to be a little bit of, I would give them more than, you know, same day, but it doesn't have to be too long, because all you're really asking for is a response about, you know, their intent to investigate and take action. So don't give them 6 months, but give them more than a few hours so they have time to read it and respond appropriately. All right, and I will pass it back to you, Rose.
Okay, and as Amanda said in her last portion, she was like, tip number 8 was, you know, tell them what you want to resolve the matter. So this section is going to go into more detail about relief that you can ask for to resolve the matter. And as Amanda said, you can actually ask for whatever you want, but these are typical types of relief that people ask for. And so we're going to go over those. So something that we want to take into consideration is that what's the purpose of relief? The purpose, okay, if it's discrimination, and Amanda gave you one example of discrimination. So we're just going to kind of go, if it's discrimination where someone's being excluded, provided an inferior service, segregated from the other students, like there's a separate prom for kids with intellectual disabilities, or there's a failure to take steps to even playing field. Like, for example, there's no interpreter or large print for a person with a visual impairment for materials, or there's an inaccessible gym or whatever. So if it's discrimination, then the purpose of the relief that you're asking for is to stop the discriminatory practice, to require them to take steps to comply with any requirements to level the playing field, like provide an accommodation, remove a barrier, an obstacle or a barrier, provide interpreters or other types of services. That's one thing that's doing. And then it's also to try to make the student whole for what happened to them. So if they, is there a way to compensate them for what happened to them where they are now? So that's if it's discrimination. So that's your goal of the relief. In harassment, your goal is, the school's goal is supposed to be to stop and prevent the harassment. So stop what's going on now, prevent future harassment to this student, protect that student who's been targeted for that harassment, and then remedy the effects on that student. So for example, what if a person has experienced the trauma, as Amanda said, for going through certain things, then maybe they need counseling. They might need some counseling services to help them overcome the feelings that they had from this experience. And in all, another type of goal for relief is to prevent retaliation. So it's been reported, you've been told about it, you've told them about it, or you filed a complaint and maybe it resulted in some changes. Maybe a teacher had to not be the sponsor of that club anymore, or maybe they had to undergo a lot of training or something, or maybe they got disciplined for it. You want to make sure that then the school should be making sure there's no retaliation. So that should be part of the relief package. So we'll take those one at a time. Those are our overall goals, and that's what we should think about when we're going through this next section. And it was important in the notice. So it becomes important what you want and being able to articulate what you want from the notice to later when you learn about internal grievances, and when you file with an outside agency if you need to. All this information we're going to talk about now, that helps in any of those things, because you're really asking for pretty much the same thing along the way, unless things got worse and you're asking for more of something, or if they'd have fixed it and nipped it, right away, maybe there would only need to be counseling, etc. And as it progressed, there needs to be more things going on. So one of the first things that needs to be done is protecting the student who's been the target of this discrimination or harassment. So this is more likely to happen in harassment types of situations. But depending upon the extent of the harassment or the discrimination, it may need to separate the accused harasser and the student who's been targeted. And that may need to be done even while an investigation is going on, just to make sure until we know what's going on to put in protective measures. It might mean protecting the student might mean getting them involved in counseling right away, and taking disciplinary action against the harasser or the person you're discriminated against, so that they don't continue to do that. Now, oftentimes it might be that's if it's a school will be evaluating when they investigate. If they do find that someone's done something, they're going to use all the factors they use in discipline anyway. They're going to look at how long has that person been club sponsor, have they had any other incidents, are they interested in training and changing, how serious was it? So they'll be looking at a lot of things, and they'll be making decisions about that. But you can certainly say what you think should be done based on how severe from your perspective and your child's perspective it was. So and that's so when you ask for, oftentimes what you're asking for too is if if you've learned something from your child and you don't know the extent of things, sometimes what you're asking for is for them to investigate and to take appropriate disciplinary action. So again, schools may consider less than some sort of discipline matter, and they may consider requiring awareness training, transferring, and they may consider also some discipline like transferring the alleged harasser, who's at that point they've decided is an harasser, suspending them, terminating them. But most of the time, you know, when I think that, and maybe Amanda might say something different, but in most cases we see that when something like this happens, unless it's very severe, you're gonna oftentimes see the school requiring training and maybe a separating, you know, like the damage has been done to the relationship, to this club sponsor, student, participant, and they might have to make changes like that. Schools may also consider, I mean, when it's a student who's the harasser or who's engaging in this kind of conduct, then it's, you know, they can also be considering discipline. They can be considering, they can be considering transferring that student to a different class, suspension, expulsion, other requiring them to undergo training prior to that, all those kinds of things. When we look at protective steps, though, and I just recently saw this in a intake that came in, is that someone complains. In that case, it was gender-based discrimination. It was saying alleged sexual harassment by a student, but both students had disabilities, and that student was suspended for a period of time, and then they returned the student to the same classroom. And so the other student who had been the target of that sexual harassment did not feel comfortable. And so the school was like, well, if you don't feel comfortable, we can move you to a different class. And that's not what's supposed to happen. And when protective steps need to be made, need to occur, then it shouldn't be the student who was targeted with the harassment to be the one that has to change classrooms, change teachers, change the friends that they were sitting beside, what their environment was. It also doesn't send a very good message to other people about, if you report something, then that's, you're the one that's got to make a change. You're the one that has to deal with it. So that's another, when you're looking at things, when you're asking for relief, you want to make sure you include things in there that say you don't want your son or daughter, your child, to be penalized when they take the correct protective measures. So another key thing is training. That is, the school may need to provide training and other interventions, not only for the perpetrators, but also for the community at large, the school community at large. But I think that, and this is a point we made last night too, is that oftentimes when a parent asks for more training, or a student asks for more training, the school's response is, we do annual training. But if they're doing annual training and harassment is occurring or discrimination is occurring, then that seems to be an indicator that there's a failure on that part for that training to be fully adequate. Or it doesn't mean it may be good and it may have helped with most people to give them the information they needed, but it means that some people it may need more information may be needed. So schools really need to make training, instead of just an annual one-time thing, they need to really, if they experience an incident of harassment or discrimination of students, they really need to take another look at their training and see if either a specific group or if there needs to be more individually prescribed training. So what kind? Maybe what they do is have people look at a computer training where they go through the slides and answer some questions. And if they memorize the slides and answer the correctly, then they're finished, they get A+ and they're done. But if there's problems in the school and they've been able to persist, then maybe they need to bring in a trainer, or bring in a trainer to train the trainers, or do something more than what they're doing. And the training needs to fit the problem. So if the problem is that a student went on, for a number of students were harassed on a regular basis and they didn't know where to report it, then that sounds like school might need to do a training to train all the students about how to report harassment, and that they can report it if they see it happening to other students, and what steps do they need to take, and will they be protected if they report it. And so that, the situation will kind of give rise to what kind of training might be needed, or additional training. For example, if some of the types of trainings we see there's a lot of training out there and a lot of resources about, we think of people who are affected by harassment and discrimination are the people who are targeted to be treated that way, subjected to it, and the people who do it. And they need training, or training to help them, or counseling to overcome it, and then the people who did it to, learn what they need to do differently, or not be given an opportunity to do it again. But another class of people that we have to think about with training are bystanders. There can be bystanders who are watching and taking no action and allowing harassment to occur. And there can also be bystanders that are seeing it and don't know what to do. And they are also traumatized by the fact that they saw that happen. They didn't do anything, and they didn't know what to do. So training can be, and there are lots of resources out there for schools to look at these trainings, but training is more complex than doing an annual training once a year. The other thing and this is true in like employment discrimination, those of you who who may have a job in the community, work outside the home, most employers have a harassment policy and notice. And they do that because the courts say that if you don't have a policy and notice to how to report things, you don't have a very good prevention process. At a minimum, you have to have policies and notice. And schools do have policies and notices. But almost all of them do. And I think we're going to tell you later where you can find out about your school's policies and notices. But the thing is that, and they're pretty cookie cutter. A lot of them are saying the exact same things. But when a school has a lot of problems, the same thing with training, they may need to pull that out and talk about it again, and they may need to revise their policies to make more of an affirmative statement about why that they are an inclusive school, and they may need to take steps to, show that commitment to having equality and equity, and to have a school that's safe and free from harassment and discrimination. And they may need to put in more steps about what to do when it occurs, but there can be ways in which that can be done. And one of the things that we have included in some of our resources are some different model policies. For example, ACLU has some model policies of some language that should be in harassment policies. So if you have a very cookie cutter policy that doesn't do much, that might be something that you would request, that they update, improve their policies, and follow model policies such as ACLU's policy. The other thing the other thing that could be a problem with policies is they exist and they're pretty good, and they don't necessarily need improvement, but people don't know how to access them. And so it's not well known, the name and contact of the people they need to talk to. It's not easily found. And if that's the case, it might be that it just needs more widespread distribution and training about it on the school's website. It's in more than one place and it's easy to find. And those are things you can ask for. You can ask for them to be, put on the website, put on their Facebook page, that there be a school school meeting, school type of meeting for all the students in which they go over it. So if you don't know, well, another thing that you can work on is, as I said before, is retaliation. So one way to kind of relief that you can ask for there is once you report it, it's unlawful once people report discrimination to then face an adverse consequence because an adverse action by the school because they reported it, or by a student because they reported it. That's if that happens, that's a separate violation of the ADA and Section 504 of the Rehabilitation Act, and can also be subject to a complaint or an internal grievance. But what we don't really want is to have to file another complaint. We want to avoid retaliation. So some of the things you can ask for is for there to be a very streamlined system for you to be able to, if it happens, you to be able to check in. There'll be a check-in to see, are things going well? Has the student experienced any problems as a result of that? And where there's some people checking about that and looking into what's happening with that student and taking a look to see if anything negative is happening. And then finally, if you don't know, if your school's website isn't very user-friendly, or you can't find it, there is a source that you can use, the Arizona School Board Association Policy Bridge. We've put the link here, and and Amanda has added it to the chat. And this is a link where you can go and you will find all the school districts listed in alphabetical order, and you can click on that and get to their policies. It's pretty easy to use. And if you are, the charter schools are not on the policy bridge. So you should go to your charter's website, and if it's not on the website, make a written request for the policy. And if it's a corporate charter school with a corporate office, go straight to the corporate office and ask for it. And the last thing we talked about is, like our compensatory education or damages, or compensatory services such as counseling if someone is still experiencing trauma or distress or anxiety because of the way that they were treated. If a student has missed school because they didn't want to go to school, and there was an issue with getting them to attend school regularly because of the discrimination they experienced in the extracurricular area. Those are areas where you might ask for compensatory education to help them make up for what they lost. Sometimes it's not, this is where the creativity can come in. What do you do if you were, like, say you were denied the opportunity to participate on a team where you could, and the season is over, and you were denied and the season was over. Maybe you could ask for something creative, like the opportunity to get some coaching or training in the community, and for them to pay for that service so that you could be ready for the next season, or that you were going to do that activity because it would allow you to be fit. And so you get a gym membership for 4 months or something like that. That's where you can really be creative, like Amanda said, and ask for things that you maybe couldn't, that you could, you're just thinking of creative solutions to try to resolve a problem. Or if you were denied the opportunity to participate in for cheerleading, compete and participate in cheerleading, and it's the off season, and you are given a chance to go to cheer camp that's in the community somewhere, so that that student could get ready for it next time. And so those are the different kinds you can ask for. And I don't know, Amanda, do you want to add anything to that before you start talking about internal grievances and complaint options?
No, just the last point on here. We do not normally deal with compensatory damages, meaning like money damages. Typically, for education type complaints, we're mostly looking at the creative solutions that Rose was talking about, different opportunities, fixing the harassment or the bullying problem for the future, trainings, that kind of thing. But if a student has been injured, you can pursue a personal injury type of lawsuit eventually. And so if you were to do that, money damages are an option in that scenario. So when we're trying to informally resolve things before we've gotten to that point where we've actually filed a lawsuit, you could bring it up and you could ask for it, as a result of whatever happened to my child. They've been physically injured, they've been emotionally injured. And so we want money to help make them whole for that. So that, that's an option you can ask for. It's not very common that is awarded, so don't count on it, I would say, but that is another way you can look to resolve it.
And if your child has received serious injuries, then you would want to consult with a personal injury attorney, one who's experienced in suing school districts or public entities, because then they know about the special requirements for doing that.
Absolutely. And here at the center, we don't do personal injury law. So that is not an area where we are experts, but we do know that you want to consult someone who is an expert pretty quickly, because there can be some tight timelines, like Rose said, when it comes to suing a public entity like a school. You want to get that advice right away so you can be timely. All right, so we are going to now talk about using internal grievance procedures. So what we mean by internal is you're filing a complaint within the school itself and asking the school to handle it. So this is the next step after you've sent your letter, but it's before filing with an outside entity, which we will also talk about. So filing an internal grievance. So again, we've shared the ASBA policy that should be in the chat now. So the first thing we would say is look for the school's own policy about how to file reports of harassment or discrimination, and follow the steps. Do it right, so that the school can't say, well, you didn't do step 3. You'd be like, yes, I did every step that you asked me to do. I did everything I was supposed to do, and yet you didn't take appropriate action. So look for that on the website, look on the school's website, ask the school administrator to send you the policy if you can't find it on your own. Again, I think I said this at the beginning, even if that policy says, yeah, you can make a verbal complaint, we would recommend putting it in writing anyway, because that way you have evidence, again, of what your complaint was, when you submitted it, and who you submitted it to. And if you're going to do it like a hard copy, paper copy that you walk down to the office and hand to the principal, make sure you ask the principal to timestamp it and make a copy for you, so you have a copy to take home. And that may be the easiest method for you. For me, I would rather send an email, because then I have that electronic record that it was received, the exact time it was sent, and I've got that copy that I can produce later. But for some people, they prefer to have those hard copies. So whichever way you submit it, just make sure you keep a record for yourself. Again, very similar to the letter we talked about at the beginning, be specific about what's happening. You may want to identify witnesses as well. So if you know, for example, that the lunch lady saw this happen in the cafeteria, you could identify her by name and ask that she be somebody the principal or whoever's investigating this speak with, to get her perspective on what happened. And you should definitely ask that you be informed of the outcome of the school's internal investigation. So again, look at the policy and see if it says that you'll be informed. And definitely, check in and follow up. Sometimes parents will file a complaint and they don't hear anything for months and months. And so they kind of leave it at that. But we would recommend, check in. Don't expect a resolution overnight. It's not going to happen super quickly, but you can check in, I would say, once a week, especially if it's continuing to happen to your child in the meantime. Do check in with the person who you submitted the complaint to. Ask, how's the investigation going? Is it close to a resolution? When can I expect to hear the outcome of this investigation? Because typically, they may not share all the details of what they found, but they should probably share some kind of outcome and the action steps they're planning to take to protect you or your child going forward. All right, and I'm going to speak a little bit about when we file a complaint with an outside agency. So we've tried the letter, we filed an internal complaint. Now we're going to try to file a complaint with an outside agency. Now I'm saying it as if that's the order you have to do it, but you don't have to exhaust one of those steps in order to go to the next step. These are all options at any point. You could go straight to filing with an outside agency if you'd like to do that. But these are all options available to you, and we're kind of going through them in order of intensity, for lack of a better word. So you could start with that letter, and you definitely do want to put a school on notice, but you don't necessarily have to use that internal grievance procedure first. You could go straight to one of these outside agencies if you prefer to do that. So the one we're going to focus on, the agency we're going to focus on the most, is called the Office for Civil Rights at the U.S. Department of Education. And this is the office that is in charge of enforcing Section 504 and Title II of the Americans with Disabilities Act when it comes to public schools. So those public school districts, those charter schools, and even publicly funded colleges and universities and trade schools. OCR is required by law to enforce these laws in those places. We will talk about a few other agencies you might consider filing complaints with, but this is the main one to keep in mind. So who is able to file a complaint with OCR? It doesn't have to be the student or the parent of the student. It can be anybody who knows about the discrimination that's happening. If it's not the student who's being targeted or their parent, but a teacher or a bystander who wants to file, you may be required to get the consent of the person who you're filing about in order to complain on their behalf. Another way you could file is not just on behalf of a single person, but you could do sort of a class complaint if it's something that's happening to, let's say, all kids in wheelchairs are being denied access to field trips because the school doesn't have an accessible van or bus. Or, that if there is a separate prom for kids with intellectual disabilities, that could be a class complaint on behalf of every child in the school who has an intellectual disability. So it doesn't necessarily have to be one person. But it's good to have at least one named person involved, because the Office for Civil Rights is going to want to speak to somebody to get their story and find out exactly what's happening and how it's impacting them. And again, like I said, if you're filing on behalf of somebody else, you are going to probably need to get their consent or the consent of their parent in order to name them in that complaint. So what's the deadline for filing one of these? So it's important to keep in mind timelines, because you don't want to miss the timeline and lose out on your chance to file, which again is a good reason, if you're running up against one of these timelines, to maybe jump ahead and file this type of complaint instead of waiting and filing a different complaint. So for OCR, it's a 180-day timeline, but it's 180 days from the last act of discrimination. So if you've been being bullied for 3 years, they're not going to say, well, it started 3 years ago, so we don't care, it's too late. As long as the last time the bullying happened was within the last 180 days, you should be good to file the complaint about that, continuous bullying that's been happening. Now, sometimes there are exceptions. So if you do file about something that happened more than 180 days ago, they are going to ask you to show good cause for your late filing. So why is it that you filed late? And it might be that there was information that was withheld from you by the school. That's usually the best reason that you could provide is, well, I didn't know that the school was forcing my child to, wheel their own wheelchair down the street when the school went to the park to play, and everybody else got bused because they didn't have an accessible van. I wasn't aware of that, and I just learned it. And so because that information was withheld from me, now I'm just finding out about it. It happened a year ago, but I'd still like to file. So if you have good cause, which typically means you didn't have access to the information, they may waive that 180-day period. OCR has discretion to decide about that. So sometimes people will say, well, I was sick, or COVID-19 happened, or, I had so much else going on in my life. And sometimes OCR might decide that's good cause. Sometimes they might not. So if you file more about something that happened more than 180 days ago, you're kind of up to the discretion of OCR as to whether they'll take that complaint or not. So when in doubt, file early. Try to get it in early so you don't have to leave that up to chance. So again, this question, do you have to use that internal grievance proceeding before you could file an OCR complaint? And the answer is no. You could go straight to OCR if you want. Now, I think it helps to show that the school was being indifferent to the discrimination if you can show that you alerted them, you sent that letter or you filed an internal complaint, you told the school what you wanted and what was happening, and yet the school ignored you, or they took, steps that just were inadequate and didn't resolve the problem. So if you can demonstrate all of that to OCR, you'll have an even better complaint at OCR, but you don't have to do that first. You can go straight to OCR. The school might say, we're shocked, this is the first time we're learning about it, but you have the right to do that. And then OCR can help facilitate that resolution process. So you definitely don't have to exhaust the internal remedy first. Now there is another timeline exception here that I'll throw out. So if you do decide to use the internal complaint process first, you can go ahead and do that, file an internal grievance, let them do their investigation. And then once their investigation is resolved and they say, we don't think there was discrimination, or, okay, there was discrimination. So we suspended the other kiddo for 1 day and now they're back in school and they're still harassing your child. So either the investigation didn't find what you think it should have found, or the remedy that the school is implementing is inadequate. Then you could say, well, even though I filed this internal grievance, it didn't solve the problem. So now I want to file an OCR complaint. If that's the case, OCR gives you an extra 60 days. So even if now we're outside that 180-day original timeline from OCR, it's okay, as long as you now file within 60 days of the resolution of that internal grievance process. So it's a shorter timeline. They're not going to give you another 6 months after the internal grievance, but they will say, okay, you tried another process, it didn't work. So now, as long as you file within 2 months of that internal grievance process being resolved, we'll still look at the issue and determine if we think there is discrimination that needs to be addressed. So how do we prepare our complaints? We want to make sure that they're compelling and that they get opened up by OCR for investigation. So there's certain facts and details that you have to make sure you include. They're necessary for OCR to take a case and open it for investigation. So contact information, very important: phone number, email, how to reach you, address, all of that. Especially if you're not filing on your own behalf, you want to be very clear about who you are filing for. If it's your child, if it's your grandchild, if it's a class of students, be very clear about who's being discriminated against. And then you need to include the contact information for the adverse party. So the school, you could include, if it's a specific teacher, you could include their name if you want, but really it's the entity that you are asking to be investigated. So including the superintendent or special ed director can be helpful, because OCR may need to reach out to them to get their response to the complaint and ask them for records or questions. But really make sure that you're putting the name of the school. And something to keep in mind too, especially with districts, I know this can be confusing, is, I don't want to use a real life example, but my kiddo goes to school A in District 3. So school A is a public entity, but it's part of District 3. So when a kiddo's in a district, you really want to be clear that yes, the school is making a mistake, but sort of the legal entity, the agency overall, is actually the district. So make sure, as to the extent you can, that you're including both, not just the school name, but the entire district, because the entire district is legally responsible for making sure your child is safe and not being harassed at school. And same for charter. So sometimes you've got charter networks and your kid's at a specific school within that network. So I would list both, because sometimes that gets a little fuzzy too, which one is the actual legal entity. And then again, similar to the letter, you want to include a description of the discrimination that's happening. You want to include as much evidence as you can. Again, if you've got attachments, I think if you're submitting online, which is an option, you can upload attachments, or if you're submitting via email, you can include attachments. So, here's a photo of what they did to my child. Here's an email I received. Here's an audio recording of a conversation I had with the teacher. Anything that you have, submit it to OCR so they can take a look at it. So here's ways you can submit. So you can use an online form, and that's actually nice because it makes sure that you fill in the blanks for the certain pieces of information you have to have, like contact information and things like that. But you are able to kind of free form write a letter yourself, as long as you include all the required info. And then you can email, mail, or fax it. So In Arizona, our OCR local office or regional office is in Colorado. So you're going to want to send your information to the Denver address that's here and the Denver OCR email address if you want to do that. We definitely recommend trying to do it online if you can, fax and mail, especially during COVID, where a lot of people are not in the office. It's just going to get to them more quickly and more reliably, probably, if you can send via email or through the online portal. But, you know, again, when in doubt, send it multiple ways. You can mail a hard copy and email it just to make sure that it gets there. So then we also get the question, well, I just want to go straight to court. I want to sue them. I don't want to waste time with this. Do I have to do this first? You don't. So it's different from IDEA, which is where IEPs come from. That law has an administrative exhaustion requirement that says you cannot go straight to court. You can't just sue schools under IDEA. There's other steps you have to take first. But Section 504 and the ADA don't have that requirement. They don't require you to file with OCR first. If you want to, you could go straight to federal court and file complaints under Section 504 and the ADA. So why bother? Why shouldn't we just go straight to court? Well, there's a number of reasons. One, an OCR complaint is free and going to court is not free. There's filing fees. If you want to be successful, you're probably going to have to hire a lawyer, which can be very expensive. You may need to pay for expert witnesses. There's going to be a lot of expenses involved in going to court. OCR, it's simple. You know, you're sending an email, you're doing it all yourself. And then, to be honest, OCR does the investigation. So they reach out to the school, they gather the records, they interview people. They're doing a lot of the legwork that you would have to be doing or your lawyer would have to be doing if you went straight to court. Another benefit is it's faster typically. OCR has been a little bogged down recently with their times, but it's still generally a lot faster than if you were to file and go to court, because there's a lot of back and forth motions practice and just long waits to actually get your complaint before a judge if you're going to court and getting a decision. So it can be a lot faster to get the resolution you want for yourself or your child if you file this complaint. And you still get really great results if you do this. It's not like, well, you know, I'm not going to get as good of relief as I would get if I went to court. You could still get very good relief. It can involve all the things Rose talked about, you know, individual relief, like moving a kid from one class to another, or having a teacher go through specific training, changing policy for the whole school. So there's a lot of good that can come out of this, and it's not necessarily better than what you would get if you went to court. And filing an OCR complaint doesn't mean you can never go to court. In fact, once you file, based on the results, they will probably put at the end of the letter, you still have the right to file a lawsuit, a private right of action if you want to do that. So it's not precluding you from going to court later if you should choose to do that. And the timelines for going to court are longer than for filing with OCR. So you're not as likely to run those timelines out. So we definitely think OCR is a better starting point than going straight to court, but just be aware you can go straight to court if you want to do that. And I'll pass it back over to Rose. Rose, you're muted.
I was trying not to make noise during your presentation there. Okay, so the process for filing a complaint with OCR, just a few things what to expect. So first, after they receive that, after they receive your complaint, you're probably going to hear from someone at OCR who's going to contact you regarding the complaint, clarify some facts and details in order to take the next steps. And oftentimes that interview, if you could advance the slide, please, Amanda. Oftentimes they would interview, they might interview the parent who filed it, but depending upon the age of the student, et cetera, they might want to talk to the student who's experienced the discrimination too. So, but they will usually, they'll have that call with the parent, unless, you know, especially if the student is under guardianship or a minor, they would include the parent on that. And they will want to clarify the facts and details so that they can make sure that they have jurisdiction, that they are allowed to look at this and to, you know, be able to determine if they're going to accept it for investigation, and then, you know, look a little bit at the scope. You will generally have to, in most cases, you have to sign a consent form to allow OCR to share information as part of the investigation. And then because they're going to need to tell the school what's going on, what's kind of the allegations, so that they can get the school's response as part of that. And they, as Amanda hammered into you guys, you got to file timely, because OCR may not investigate claims that are not timely, or that if true wouldn't violate section 504 anyway. So if you allege something that's just really not stating a claim about disability discrimination or harassment. So they will, and they get to make the decision. So if it hasn't been 180 days and you still can file that paperwork, don't count on a good faith exception. Go ahead and do it. So now we've both just kept hammering that point home. Okay, so next thing would be what do you expect next? If OCR is going to investigate, it will send a letter of notification, and that's going to tell you the complainant what allegations are going to be investigated. So they could find that some of the things that you said would be violations of section 504 if established or proven, and so they include all those. But maybe you included something else they didn't feel they had jurisdiction over, or one of your claims was untimely. So they can pick and choose, but they'll let you know in that letter what they're going to be investigating. They'll also tell you about the facilitated resolution process, and that's basically an opportunity to mediate, to do conflict resolution. And we're going to talk a little bit more about that in the next slide. They're also going to write, up front, tell you about the right to file a private suit in federal court, if whether OCR finds a violation or not. And then they'll let you know who's the person that you talk to if you have questions. And you're also going to get a number. You're going to get a number that is the investigation number. And when if you send emails or you send correspondence or anything, or follow-up documents you think are really important that you didn't give in the first round, you're going to want to include that number on all your correspondence, emails, etc., back to OCR. So after what to expect after, what about this facilitated resolution between parties, or FRBP, because that's a mouthful, so we just say FRBP. Well, one is that's an opportunity to try to resolve it, to sit down with a mediator or virtually sit down with a mediator from OCR and someone from the school who has authority to reach a settlement, and then you to see what you would want. So you can pull out those things you asked for in the past, or the relief that we talked about, those creative ideas, those training policies, whatever you think is necessary in this case, and take that with you to talk about at the meeting and try to get that. Benefits of it, as Amanda reminded me before this started tonight, is that it is one of the few opportunities where you, as a parent or a student, have a seat at the table and you can really be a part of the decision making, because there is no FRBP unless both parties agree to it and sign it. So if you don't like what the school is offering and they say, that's it, that's all we're going to offer, you can say, okay, I don't want that. But in other areas, later down the line, OCR and the school may decide that's all it takes to resolve this issue. So you really have a seat at the table. And you can ask for things those creative things that you might not get if OCR decides what relief is necessary later on down the line. The mediator that is trained and a member of OCR staff, and they are not a decision maker, and they are to be neutral and they're there to just facilitate and get help with ideas. And if an agreement is reached, write it up. You can be on your own at that, or you can ask for an attorney to attend with you. Things that you want to keep in mind about this, though, is that OCR does not, this agreement is between you and the school. And OCR doesn't sign off on it, and they're not approving it, and they're not monitoring it after it's done. But if the school does not honor the agreement, you have the right to file another OCR complaint. And you also, I don't know why you wouldn't also, Amanda, am I right? You'd still have the right, just as you would with an agreement under IDEA, to enforce it in court too, like a settlement agreement.
Yes, I mean, I think you want to be careful with what you put in a settlement agreement and make sure it's a tight settlement agreement and it includes an enforcement provision. And I don't think we are going to have time today to go into everything you should look for in a good settlement agreement, but I'll pitch really quickly. If you go to our website, we do have blog posts and videos about how to write and enter into a good, tight settlement agreement that would be enforceable in court. So yes, I think you're right, Rose. As long as you write it such that there's an enforcement possibility, you could go to court to enforce this type of agreement.
And also, you don't, even if you choose or you can't afford or you choose not to have, you could have you could talk to an attorney about this before you go to mediation and get language that you would want to specifically add. Like you could tell them what relief you want and get ideas. And Center does attend, we can't serve everyone that contacts us, but we do, that's one of the services we can provide is attending mediation or providing consultations about mediation to prepare someone for mediation. If the parties don't reach an agreement, then the investigation is going to move forward. So after the facilitated resolution between parties, the next thing that might happen is if it goes forward, if you reach an agreement, you're done. And then you can file another one again if they don't follow it. But if it's not, then the investigation is going to go forward. And at that point, we're going to, if the OCR will complete its investigation, and they will issue a letter of findings to both the complainant and the school. Something that can happen in the middle of that is the school can approach OCR and say, but you don't need to complete an investigation. We're just going to do, all the stuff to resolve the matter. And they offer a proposal. This OCR can look at that, and if they feel that that would resolve everything, and they and based on where they were in their investigation, they accept that, they could accept that. You will get a notice of that. But you didn't have a seat at the table to help design that. That's why it's really important when you file your complaint that you put in all that relief that you want. I've done complaints, I've represented people on complaints where they didn't ask us anything, but they just issued a voluntary resolution agreement between the school and them. But many times they looked at that relief and they included a lot of that relief, sometimes all of it. So that's still a good reason to do that. But in other cases, they will finish their investigation and then try to negotiate a resolution agreement with the school district. Again, they may ask about what you want, but sometimes they just make determinations. They may even ask some follow-up questions to decide that, like, well, you said your child had to go to counseling. Do you have receipts for the counseling, etc. And this is one where if OCR enters either a voluntary resolution agreement or a resolution agreement after an investigation, they will monitor it and they will expect them to provide reports or information to confirm that it has been completed. They can negotiate if a voluntary agreement is being negotiated, they can negotiate for 90 days. And if in this case, if the school doesn't do what they said in the resolution agreement, OCR can refer that to the U.S. Department of Justice and ask that they enforce it. And they can ask for withhold federal funds or for litigation, and that is a remedy, but I'm going to say I haven't heard of that. I think I've heard one school being threatened many years ago. That is not a very likely scenario.
Yeah, I would say if the school has legal representation, the legal representation would be committing malpractice if they did not encourage the school to follow the agreement OCR ordered, because otherwise, yes, they would be facing litigation or withholding of federal funds from the government.
And we do see other places to file. That's me, right, Amanda? Or is that?
Yeah.
Okay.
No, you go for it.
Okay, so there's other places that you can file. You can file a complaint with the Arizona Department of Education, and it may be appropriate in some. If the bullying harassment involves denying a student their rights under IDEA, that would be a reason to file an ADEA complaint. And we have provided you with a link to all the dispute resolution options and how you file a complaint with the Arizona Department of Education. And we're going to go through these a little quickly so that Amanda can give you some more tips. But you can also file one with the State Board of Education. They accept complaints against educators. And they're looking at educators who have acted unprofessionally or immorally. And that can arise in severe harassment cases. That could be an example, or harassment cases, that could be an example. So we do want you to note that caution in this one, that if the State Board of Education finds that your complaint to be frivolous or filed in bad faith, it can assess fees against you. So that's one where you want to have lots of evidence. And being wrong, them going, that's not where you get assessed fees, but it's where you acted in bad faith. You don't have anything to back you up. You might be, they might feel the parents making stuff up, nothing to substantiate it. That's kind of acting in bad faith. Next one would be, you could file a complaint with U.S. Department of Justice. They investigate allegations of violations of ADA, Title II of the ADA, but federal government doesn't want to duplicate services. So if you file a complaint with DOJ and OCR, they're both not going to investigate, and one's going to take the lead. And so we can, one tip to deal with that is to consider filing with both, but because they both have deadlines of 180 days, but stating in your complaint that you have filed with both agencies and you'd like them to decide among themselves which agency is better suited. We also, Amanda might disagree, and that's fine, lawyers can disagree, but I think Department of Ed is a really good place to go with an education discrimination thing, because they have expertise in education, and they have they're pretty transparent about what they do and the steps that they take, and whether, and you'll know very early on if they're going to take your case. So we think OCR can be a really good avenue, and DOJ is looking at a lot of different things, healthcare discrimination, a lot of different areas, and they can't have an expertise in all the areas as much. So
I agree.
Okay, and filing a lawsuit, as Amanda already told you, that's an option, and you do not have to exhaust all these steps first. And that I think we've told you most of these things already. So I'm gonna move forward so that Amanda can give you some complaint filing tips.
All right, yes, I want to make sure we get through these and then leave a couple minutes for questions. So just some tips. We want you to file successful complaints that get opened for investigation and get you the result you want. So again, we've already given you a lot of the tips. But again, especially if you're talking about harassment that's led to a hostile environment, such that your child isn't even going to school anymore, or isn't happy to go to the sports practices or be involved in the after school activity, list all of the incidents. Try to be really specific, really detailed, include a timeline if you can. All of that is really helpful to demonstrate, again, that pervasive nature of the harassment. You may not be a lawyer, but these laws are publicly available. You can look them up. You can see the exact language that 504 and ADA use. Google is your friend. It should be highly available to read through this, and you can look at both the statute and the implementing regulations. So use some of that language when you're filing these complaints. So some common phrases you would see would be denial of a request for a reasonable modification, denial of an auxiliary aid in service, denial of access, segregation, inferior services. These are things that are kind of key parts of 504 and ADA, and it's helpful if you can put the facts of your case into the context of the statute. A really important one is to try to be professional and sound objective. I think it is important for the kid themselves to say, I felt excluded, or I felt so miserable I couldn't continue to go. But as a parent, if you say, I was so mad at that teacher and I hope they get fired, that's not the tone you want to bring across in your complaint. You want to say XYZ happened. This was the result. It was a violation of the law. And just try to be really formulaic in that and show that you're measured and reasonable, and the school is the one being unreasonable, not you. So a couple quick examples to kind of show that formula. So this is what happened. This is why it violated the law. On November 3rd, 2019, my son's class went on a field trip to the zoo. I was told that my son would not be allowed to go on the field trip unless I accompanied him, because the teacher was worried about my son running away from the group and wanted me there to manage his behaviors. And then I said I've attached some evidence, which I think can be helpful. My son has autism, and elopement is a behavior related to his disability. None of the other parents were told they were required to chaperone the field trip. Therefore, my son and I were treated differently on the basis of my son's disability. This constitutes discrimination in violation of Section 504 and the ADA. So that's a really simple example. Yours would probably have a lot more facts and more details, but it kind of shows how you want to tie the facts to the law. Another one, and this one kind of ties back to what Rose said at the beginning, that kids can be members of more than one protected class. And sometimes discrimination happens on the basis of both protected classes where they're sitting at the intersection. So this is an example of that. My child identifies as transgender and has dyslexia. They participate in the school marching band, which has practice on the school football field in the mornings before school and performs at school sports events. My child has experienced extreme bullying from other students in the marching band, including name calling related to their gender identity and learning disability, and property destruction. See attached photograph of my child's instrument, dented and covered in graffiti slurs. My child and I have brought each of these incidents to the attention of the school, but the school has refused to take any action to stop the bullying. The school's deliberate indifference to this gender-based and disability-based harassment violates Title IX of the Education Amendments of 1972, as well as Section 504 and the ADA. So you don't have to file two separate complaints. If it's any of the civil rights laws we've talked about, you can file one OCR complaint and allege everything that's happened under both laws. And then here at the end, we've got links to some resources that may be helpful. And I don't know, Rose, if you wanted to talk through those briefly.
One is as we said, there's ACLU has created model anti-harassment and discrimination policies for schools that have good language about schools' commitments to a safe environment. Also, there's a National Center for Safe, Supportive Learning Environments. They have a lot of resources for about what, training policies, activities that could be helpful to a school to take on when their typical policies and have not been enough. And also there is another national organization that works on harassment and bullying that has that, as well as we have a couple of resources from the that organization. So we'd like to answer any questions that you have, if we could.
Yeah, so feel free to put questions in the chat, or you can just unmute yourself. Okay, so I see one in the chat, Rose. I'll read it, and if you want to answer it. So some parents have shared that discrimination occurs with a coach, for example. So it's the student's word against the coach's. Any advice for parents in that situation? Also, what advice would you give a parent or student who's afraid to speak up for fear that the coach will treat them differently once a complaint is made?
Well, we can tag team on this one too. One is, I think even if there's just one person's word against the other, it's helpful to go ahead and make put them on notice, because somebody, even maybe another student complained last semester and you don't even know about it, And so maybe, or maybe they've gotten some, maybe an assistant coach, when they're asked specifically about it, they will give some information. They'll say, yeah, I did see that. So there may be witnesses, and if you know the witnesses, include that. Sometimes witnesses won't back you up, even though they saw it. So, but I think it's worthwhile, because it's worthwhile to go ahead and make the complaint and give as much, because your son or daughter may be believed over the other, or they may have had more information you don't even know about that they have to take into consideration when they receive that complaint. Retaliation is, one is when you make that complaint, you could also say, by making this complaint, my son or daughter is very concerned that they will be retaliated against, and I would like you to tell me what steps you're going to take to prevent that from happening. I don't know, Amanda, any more tips about that?
No, I mean, it is tough, but that's why you ask for an investigation, right? Whether it's OCR or the school, they're going to talk to the witnesses, come to a conclusion. But I do understand it can be intimidating, but I just reassure them there are protections from retaliation. So I feel bad because I know there may be other questions, but we are a little past 7 and we do have to let our interpreters go. But if you do have additional questions, you can always reach out to ACDL and complete an intake. Definitely check out our website. We have a lot of resources about this type of thing. And then Natalie is going to also send out copies of today's presentation as well.
All right. Well, I want to thank Rose and Amanda for their presentation this evening. I will put my email in the chat if you want a copy of tonight's PowerPoint and last night's, and we will have recordings. I'm happy to send that out. And I wanted to give a big thanks to Alma in our Spanish interpretation room. Thank you. Krista, who did our closed captioning this evening, and Sandra and Tiffany for their interpretation. Thank you so much for your help. And if you have any other questions, please email. And if not, wish you a very good evening. Thank you for coming.
All right. Thank you.